SJC-12844 in the matter of an impounded case.
Ms. Musgrave, good morning.
Good morning, Your Honors, and may it please the Court. Emily Canstrom Musgrave on behalf of the appellant, Massachusetts General Hospital. The appellate division's interpretation of Section 12A is contrary to the plain language of the statute, defies legislative intent, and endangers patients. The additional argument on appeal, moreover, that the statute allows no restraint in an emergency department reads the statute to absurdity and defeats the primary purposes of this law: protection of the patient and others from harm and rehabilitation of the patient. Section 12A ensures patients in psychiatric crisis who are a danger to themselves or to others will be safe and cared for while caregivers seek a bed in an appropriate facility. The appellate division's order deprives patients of this care for 3 reasons.
I'm reminded a little bit of this sort of, that story about the person stuck on the boat and they can't dock. How long can you stay here in the emergency room before it becomes a constitutional problem? I understand there's no time frame in the statute on the initial phase, but is there a constitutional limit on how long you can be in that facility, and is 4 days running into that?
So 2 things, Your Honor. At this point in the statute, we'd be talking about an emergency department, so not an inpatient facility.
Right.
But in terms of the time limit, Your Honor is right. The statute doesn't provide one. As a constitutional matter, the answer is for a reasonable amount of time in the circumstances, and that reasonableness is determined by qualified healthcare providers who will continue to assess the patient during that time, exercise their...
But don't we also have to consider all the different time constraints in the rest of the statute, which are all brief? So that's where I get confused, where the next stage is 3 days, and the stage after that is how many days? After the evaluation, you've also got to make a relatively quick determination. A judge has to issue a decision within, I can't remember, 10 days. So how do we analyze that first period in that statutory context?
Your Honor, I think the existence of the short time frames that follow from this period of emergency triage, assessment, and care, actually the fact that there are short time frames that follow supports a reading of this period of time as a safety valve in the statute, a place where patients who really are in psychiatric crisis can again be safe and be kept there long enough to ensure that their safety will be maintained so that they can be moved to an inpatient facility, to Your Honor's point.
The basis to restrain somebody under 12A is simply a reason to believe that the failure to hospitalize would create a likelihood of serious harm. And that can be done by a police officer or an EMT, correct?
It can be done by qualified healthcare providers
Or
in an
by a police
emergency
officer.
situation, a police
Or
officer.
by a police officer.
Right.
Okay, and then the statute provides that a physician at a facility, meaning a psychiatric facility, must then determine that the failure to hospitalize that person would create a likelihood of serious harm. And the law says if you get a physician to say that, you get 3 days before you get to go before a judge, correct?
Well, the hospital has 3 days to continue to assess the patient and to determine whether continued commitment would be appropriate for that patient in those circumstances.
Right, but that 3 days is triggered by a determination by a physician that the failure to hospitalize that person would create a likelihood of serious harm. That's what gives you the additional 3 days.
That's what gives you the 3 days to help make that determination.
Right, so basically the law says reason to believe is enough to restrain. A physician's determination is enough to give you 3 days, but then after that, only a judge can decide whether or not you can continue to be held.
a judge taking into account the testimony of medical professionals.
So isn't the problem here is that the ER is a no man's land in terms of the law, that the law simply doesn't anticipate that the person's going to be delivered to an emergency room as opposed to a psychiatric facility?
A couple points on that, Your Honor. No, I'd say beginning at the beginning, we'd say there is no problem here, but
Well,
it's
there is,
not
I mean, yes, I mean, there is a problem in the sense that the law makes speed of the time of the essence, and basically, if the person is brought to a psychiatric facility right away, they have a right to counsel, a right to appointed counsel, a right to an emergency hearing. In the ER, they have none of that. They're in no man's land.
That's true, Your Honor, but it's not a no man's land. It's a place where this person is being safe, kept safe, cared for, triaged, and assessed, because the getting to the facility involves a complicated assessment that involves not only finding a bed in an appropriate facility, but ensuring that that bed is, as I say, appropriate with the patient's comorbidities, with other things that may be going on for this patient. And the qualified healthcare providers in the emergency department have no incentive to hold a patient one moment longer than is necessary. They're working with all expediency to find that inpatient placement for the person.
One hopes that they are working with expediency. But there's a treating physician at MGH who acknowledged that, quote, when people come into the emergency room or they're on the medical floor and there's a thought about them going to an inpatient psych unit, they institute a 12A. They can sit there for days to weeks, and sometimes they change them as clinical material comes up or the condition of the patient changes. They'll renew them or rewrite them. That's expediency?
Your Honor, I am aware of that statement that was made during the commitment proceeding in this case. I think the briefs that amici filed in this case, particularly the Department of Mental Health and some of the other amici who weighed in and provided some statistics and some context for how long it is that patients generally are staying in an emergency department is very helpful here and can give the court some guidance. I think the statistic is that actually only 6% of patients are there longer than the 24-hour period, and most are there in even shorter amount of time than that. The other thing I would draw the court's attention to—
That's not true. 48, I've got 5.8% or 48 to 72 hours for the length of stay for ED boarding patients with a behavioral health diagnosis, according to the Health Policy Commission report. It's as I read it, basically about 2/3 of them are out within 24 hours, but about 1/3 of them are not.
If I'm reading the statistics erroneously, Your Honor, I apologize, but I think the point remains that although there is that statement on the record, the statistics do indicate that although some people are staying in what we call ED boarding longer than 12 hours in an emergency department, the majority of those, in fact, who are staying longer in an emergency department are those who are difficult to find an appropriate bed for in an inpatient facility. And I think this gets again to one of the fundamental problems with the appellate division's order in this case. Those would be people who are likely to be so ill as to display ongoing violence, uninsured, or perhaps children, or people with difficult physical comorbidities too that might be difficult to place. And if we follow the appellate division's suggestion that at the end of this 3-day period, the appellate division has taken from 12B and put onto 12A, these are the people that would be discharged having received no treatment whatsoever.
You don't want us to rewrite the statute. That's number one, correct?
Yes, Your Honor.
But what is the break as far as the limits of a Section 12A hold? All right, so if we say you're right, and we're not going to rewrite, that's for the legislature to do, what limits any hold under 12A?
The limit is reasonableness, which is the touchstone of any due process inquiry, and the question is what is reasonable in the circumstances of that patient. And the way that would look, I think, in practice is qualified healthcare providers continuing, as they do at MGH, to reassess the patient and to determine continuously that the 12A criteria are satisfied, and so the reasonableness would endure until either the 12A criteria are no longer satisfied or an appropriate placement has been found in an inpatient facility.
So
There be any room, I'm sorry, Justice.
I was trying to figure it out. So in the real world, it would be up to a lawyer who hasn't been appointed for a patient to say, I've been there for 48 hours. This is a due process violation?
I think it would be up to someone to challenge the unreasonableness of that detention, which I would respectfully submit hasn't been done on this
Right,
record.
in this case, I mean, it seems like there was good faith search for a bed.
That's right, Your Honor. This patient was particularly agitated, and any delay that did exist here, which again was nowhere near days or weeks, was brought about by the fact that the patient was so agitated as to require a private bed, which is more difficult to find.
But who's gonna challenge the reasonableness? There's no right to counsel. The person's not informed they have a right to counsel. All the rights that the person would have to question the person's stay don't kick in until the person is brought to a facility.
I understand the court's concern about the practicality of challenging it in that moment, and I would again say that this is a period of exigency. It is designed to be brief, and in all likelihood it will be, particularly because, as the Department of Mental Health makes clear in their amicus brief, they too will get involved at 96 hours if no bed has been found and work hard to find one.
Is the problem that there's a chronic shortage of beds? Is that the problem?
That's part of the problem, Your Honor. There is a shortage of beds, but that's not the only piece of the problem. The other issue is that it's very difficult to find an appropriate bed, so that a bed may be available may not make it an appropriate bed for this patient, which, for example, for the patient at issue here, they needed a private bed because of the patient's agitation. But it might also be that a patient is a child. It might also be that a patient has diabetes or breathing difficulties and needs a bed in a facility that could also accommodate those other issues. So it's not just about the number of beds, it's also about finding the right one.
I have questions about the constitutionality, but before getting there, just a statute dealing with Section 12 as a whole. A number of places in the statute, including 12E, the hearing in front of the judge, there's a discussion of 3 days under the statute. And there's discussion about bringing the individual to the facility that suggests, number one, that no one's contemplating in the statute some sort of hold in an emergency room until there's a bed available. And number two, that the longest you can be held under Section 12 without some sort of hearing and due process is 3 days, and I'm sure you're aware of those arguments. What's the statutory response? Because as I understand it, your response to that is, well, 12A doesn't have a limit. But we know 12A has some due process limit. So why doesn't the statute as a whole tell us that it can't be more than 3 days?
So a couple points on that, Your Honor. There is a 3-day period in 12B, and we would submit that that operates as a window of time. That's not the limit. That's the window of time that a qualified physician and an inpatient facility has to determine whether continued commitment would be appropriate. But in fact, as Your Honors made reference to earlier, the way this works in practice is that if the facility determines that commitment is appropriate, they will move in court for that hearing. That hearing can take place up to 5 days later, and then the court has another 10 days to rule on that particular commitment petition. So even beginning from the premise that there is a 3-day period of time, it's a window from which other periods of time spring. The other thing we would say is that you can't read 12A in isolation from the rest of B, C, and D. This is a phased process with escalating elements. It begins with a period of emergency restraint, where a person is to be kept safe and evaluated so that they can be moved to the facility, which would be the next step, the next phase in that process.
Sure, but the police would say, yes, you can't read A in a vacuum, and D says a person shall be discharged at the end of the 3-day period unless the superintendent applies for commitment. Obviously, when you see the word superintendent, you think that they're already at the facility, and I understand that. But again, we're talking about a short period of time, and 12A might not be if in an emergency room.
Again, Your Honor, 12A might not be the shortest period of time, but it is designed to be, as I said, a safety valve. And one of the other elements I think inherent in Your Honor's question is whether a person can be brought to an emergency department under 12A in the first place. And I do want to make sure we get to that argument. So addressing that argument in particular. What's interesting first, as a matter of text in the statute, is that 12A doesn't talk about the place where a person can be restrained. It talks about the people that can do it. And the first sentences of 12A are about the qualified healthcare providers, the medical professionals who are designated to do this type of emergency care. And interestingly, that's the part of 12A that has been amended over the years to add more of those professionals, which underscores the notion that the place where people are to be cared for in this emergency environment is in fact in a medical facility, and particularly in an emergency department. The other thing I would point out is going back to my comments earlier about the finding of a bed in a facility and ensuring that it's an appropriate bed in a facility. If that's not being done in an emergency department where a person is safe and cared for while that process is ongoing, the suggestion is that the person would be, I suppose, in the back of a police cruiser while a police officer is perhaps calling every facility in the Commonwealth to try and find a bed for this person, having not been able to assess physical comorbidities, having not been able to provide the kind of medical care that that person would otherwise get in an emergency department.
Does 12E provide for a different way of doing this?
12E, Your Honor?
Yes.
Yes, it does.
And why shouldn't we read 12A in conjunction with 12E?
I would submit that we should read 12A in conjunction with 12E in the sense that there are two different routes for a person to get to a facility. And in fact, had the legislature wanted to provide for only the 12E route to a facility, they certainly could have done so. What's interesting is that Section 35, which provides for a means of getting people with a substance use disorder to a facility, reads almost exactly just like Section 12E. It doesn't have the Section 12A safety valve, but it specifically provides that if no bed is available at the relevant time, the person would be sent to somewhere like Bridgewater. So I would submit that this is an informed decision on the part of the legislature to find an emergency way to care for patients in crisis.
I mean, isn't the fundamental problem we have here is that the statute under 12A anticipates that based only on reason to believe, somebody may restrain or authorize the restraint and, quote, apply for the hospitalization of such person for a 3-day period at a public facility or at a private facility authorized for such purposes by the department. That is, the legislature understood that the person would be restrained and then brought directly to a psychiatric facility, and that the 3-day obligation would then kick in, assuming that the physician at the facility determined under 12B that the hospitalization, that the failure to hospitalize would create a serious risk of harm. But in reality, that's not what the world looks like, and probably is not what the world should look like. They're being brought to an ER. So what do we do with a statute which assumes that something should happen which not only does not happen, but probably should not happen? I mean, you want us to read 12A to essentially say you can, based only on a reason to believe, you can sit in an ER for as long as is needed to find a bed, okay? It's hard to interpret that that's what 12A really means, but we're still stuck with the problem of a statute which is assuming something that is not true and probably should not be true. So what do we do about that?
If the court is of the view that it's assuming something that is true and probably should not be true, I think this comes back to the balance that the legislature struck in this statute, which is that there is some incursion here allowing for a safety valve and a restraint. And if the court were of the view that there is a problem of constitutional dimension with that balance, then that would be one for the legislature. I would submit in connection with the Department of Mental Health, the agency charged with administering the statute, to work on and to reassess.
Is there anything in the legislative history that answers the chief's assumption? I mean, were they aware that at the time that people were dropped off first in the emergency rooms? Do we have a legislative history to look at in this case?
Your Honor, I'm not aware of anything in the legislative history that indicates that specific awareness, but what I would note is that this is not an unexamined statute, nor is it an unexamined section. The legislature has been looking at this section for decades and has worked specifically on time periods, both in Section 12 and in other parts of the statute, and hasn't seen fit to put one here, which I do think is indicative of some conscious decision about what to do with that. I would also point out that in the late 90s, this statute gained specific attention, and my understanding is that an ad hoc committee was even formed by the district court, which included people representing all different manner of interests, and that led to some of the other amendments that happened in 2000,
So are you,
2004.
again, I don't want to put words in your mouth. Are you saying that the legislature is aware of, we can, based on what we're going to find in the record, that the legislature is aware that of this emergency room drop-off problem and has not corrected it?
I think that is fair, Your Honor, most specifically because in the past 2 years, the Department of Mental Health, working with the Department of Insurance, Mass Health, and the Department of Public Health, has issued a protocol, the Expedited Psychiatric Inpatient Assessment Protocol, that has been put in place to address the concern of what people refer to as ED boarding, that is the staying in an emergency department. And that protocol involves an escalated process involving different of the state agencies within very short time periods to help find an inpatient bed in a facility. So I do think, yes, the court can determine that this is an informed decision on the part of the legislature.
Nonetheless, whatever the public policy reasons that might exist to allow somebody until a bed remains to be there for X amount of hours or even days, you have an individual who's involuntarily in an emergency room without any counsel, without any determination by the court for an unlimited amount of days under 12A. And I'm sure you would agree that even if there's a reevaluation of the standard and proof that they've been checking for facilities every hour that might be open, that there is an amount of days where there's a due process violation.
I wouldn't agree that it's an amount of days where there's a due process violation. The due process inquiry has to work in two parts. In terms of the framework that we would suggest to be applied here, the question would be whether the statute is invalid on its face, and assuming it isn't, whether it's being invalidly, unreasonably applied in the circumstances. And we would suggest that neither of those things is happening here. Taking a step back from that framework, which we would urge be applied in this case, this represents a balance. It's certainly true, Your Honor, that the time that a person spends in an emergency department is an infringement on a right to freedom from bodily restraint. But this statute allows an incursion into that freedom, and we've said that that freedom is not absolute. This statute allows an incursion into that freedom necessary to care for this patient, to keep them safe, to exercise medical judgment and compassion, even if a patient isn't able to ask for it in the circumstances, which by definition may be true here.
So let me ask you another question. Is there any reason in the record to think that Mass General, in addition to looking for a bed in its own facility, looked elsewhere?
Yes, Your Honor, my understanding is that that's their standard practice, and I do think there is a suggestion in the transcript that they looked elsewhere too.
Okay.
All right, thank you.
Thank you, Your Honors.
Ms. Talley.
Good morning, Your Honors. May it please the Court, Karen Talley on behalf of CR. And I just want to start by acknowledging something, Chief Justice Gantz, that you referred to, which is that we have a disconnect between what the statute under 12A contemplates in terms of the reality or the landscape and what's happening currently. So we do have that practical problem. I also just want to point out, as I think is clear from the briefs, that this is not a facial challenge to the statute. This is an as-applied challenge to the statute. And as Justice Link pointed out with the quote from Mass General's doctor, that really sums up the crux of this case. This was their own witness saying that when there's a thought of somebody who's in the emergency room going to a psychiatric unit, they can sit there for days to weeks, and that there are multiple Section 12As that are initiated and then reinstituted for that potentially indefinite period of
Ask you a question
time.
before you go further with that.
Sure.
Would you say that this problem has been increasing over the past few years, or stayed the same? Is it new? Is it?
I just want to make sure I understand the nature of the problem that you're talking about.
The onboarding.
Okay.
The ER boarding.
Okay. So certainly from, DMH has been required to report to the legislature on a yearly basis since the statute was amended in 2000. And if you look at those statistics, which are, I think, noted in the DMH brief, and they're available on their website, it does seem like the number of 12As every year is increasing. I think in the last year that they had data for, it was over 50,000. So the number of 12As has been increasing. If your question and your definition of the problem is the length of time that those people are boarding in an emergency department, is that length of time growing? I don't know the answer to that. We have a lot of statistics that were given to us as part of the
Given what you
amicus
just
briefs.
said, so the legislature does know about the problem and has not done anything about it, it sounds like.
I don't know that the legislature is aware of the problem of,
Didn't you just say
ED boarding.
DMH has been required to report on a yearly basis? I take it that's to the legislature, is that right?
correct, in
So
terms
they've
of,
been doing this for years. I mean, I'm just trying to deal with the practical reality here.
right, and I'm sorry, if I could just try and answer that question. What that was in reference to is the DMH reports talk about how many people come in through the 12A process, and then how many people are admitted under 12B, and then how many people are petitioned, and it's kind of a smaller and smaller number at each stage. How many people are petitioned against involuntarily? How many of those go to hearing?
But we don't know if they're informed of how long people are ER boarding.
Correct. My understanding is that that's not included in the regular reports that go to the legislature.
Can I clarify your as-applied and facial challenge?
Yes.
So a facial challenge, of course, would say 12A has no limits, and you could be held there for weeks. As applied in this case, my notes, we have a person who was first admitted to the ER on August 10th. By August 15th, there's a bed available, and the person ends up in the psychiatric ward on August 16th, correct?
Correct.
But the information is that from the time of admission till the 16th, they're trying to find an appropriate bed for this person. So what are the parameters we should look at on an as-applied challenge as far as numbers of days and the good faith efforts of MGH to find this person an appropriate bed?
Right. I think when I say it's an as-applied challenge, what I mean is that if 12A is applied as written, the person would be taken directly to the facility. So the statute as written, that's what it contemplates. The as-applied challenge comes in because this practice has somehow developed or grown up organically, where people are instead being taken to the emergency departments, even though that doesn't appear anywhere in the statute. So that's where the as-applied challenge comes in. In terms of the number of days that would be permitted under the statute.
Seems like you've turned as applied into a facial challenge.
Right, that's,
Yeah, as applied is applied to this case. It's not as applied to the language. That's a facial challenge.
Well, I guess what I'm saying is that if 12A were interpreted as it was written, as it was intended to be interpreted, somebody wouldn't be brought to an emergency department. They would
Where
be
would they
brought
go?
directly to the facility where the 3-day time period would kick in.
because I think that's what the appellate division did, was they looked at the statute and said, well, this makes no sense, so we're going to read in the 3-day time limit to any part of the detention.
Right. I think they said that was a best practice, and we made an alternative argument in the appellate division that if, as a practical matter, the appellate division feels like, as Justice Gantz referred to, that the statute, when it was originally written, has somehow become divorced from the practical reality, that was a means to save the statute. That was a means to interpret it to avoid this constitutional problem of indefinite detention.
That requires us to essentially rewrite a statute, right?
Well, but I think that if you look at the statutory language as a whole, which is what, if this court determines that 12A is somehow ambiguous, and again, I maintain that it's silent because it contemplates the person being taken directly to the facility, but if this court interprets the statutory language as being ambiguous, that's when I think we look to the other portions of the statute as well as constitutional due process. And 12C refers to 3 days under the entirety of this section, meaning section 12. 12E, as was mentioned before, limits the 3-day period when it's ordered by a court from the time the person is apprehended, brought before the court, and is then evaluated, and that the equivalent of that 12B determination that they meet the criteria is made at the courthouse, then the person is taken directly to a facility. So I think,
Was there ever a time when, there wasn't this gap, when people were brought directly to facilities?
yes, Your Honor, I
Under
searched.
under 12A, using 12A? I'm just trying to
Yes.
say, okay.
Yes, and I searched for documentation of that. I can't say that my awareness of that comes from other than having practiced in this area for 25 years and spoken with a lot of people who remember that time when people were, in fact, directly transported to facilities
Because
under 12A.
DMH tells us, don't do that. That would be a disaster, right?
Right, and I think DMH, as happened in other states at a certain point in time, and I don't know exactly when, used to be a direct provider of these services, inpatient services, largely in state hospitals and community-based mental health centers. At a certain point in time, they sort of stepped back from that business
But
and said, well, let's provide acute
is that the
care.
bad old days when people were in those giant mental institutions that we don't want to
Yes.
return to?
Well, yes, Your Honor, I that's a separate question. I'm
But-
trying
but-
to,
But they're related, right? I mean, the reason, there was this sort of warehousing of the mentally ill in a certain period of time. You don't want to go back to those days, right?
no, we don't want to go back to those days. And in fact, this issue of a bed shortage, I think, is somewhat linked to, are people staying too long in those facilities? Are people going on criminal evaluations that don't need to?
Could I ask
to those facilities?
Justice Lang's question in another case?
Yeah.
What should have been done here? Given the practical realities of your client's mental health condition, the absence of beds, what should have been done?
Right. Well, I think, in terms of the facts of this case, we don't know why the person came, why my client, CR, was taken out of Logan Airport and brought to the emergency department at Mass General. That Section 12 and then the second, and I believe the third Section 12 are missing. So we don't know why that police officer noticed some behavior or what behavior that police officer noticed. She was brought to Mass General Hospital. I think that if the court reads the...
Sorry, I'm just asking, what
I know.
is the end result in this case? What happened to her after she was actually brought to a facility? Do we know that?
Brought to the psychiatric facility or the emergency department?
So August
It was 5
15th,
days.
August 15th, she moves from the emergency room to the facility.
Yes.
What happens to her?
So then she was given her notice of rights. She immediately filed a pro se request for an emergency hearing. They did the assessment that she met the criteria for admission. She was admitted. The hospital filed a petition on August 16th.
Okay, so that informs my earlier question. Given that this is not, it looks like there was a good basis for taking her from Logan Airport to some type of evaluation process.
Right,
What should have been done here, given the real world?
right. And I guess what I was trying to, and I was trying to answer that question.
No, but that's, you see,
before.
we have to answer that question, so why don't you help us?
Right. So I think that the assessment needs to be done. If a person's going to be brought to the emergency department, the assessment needs to be done and a bed needs to be located as quickly as possible. When I was referring to the facts of this case and not knowing why she came, there was testimony later in the 8B hearing that she had thyroid issues, that her Tegretol dosage may have been too low, or thyroid medication may have been too high, the Seroquel medication may have been too low.
There was also other evidence of some other mental illness complicating that, which presents a complicated patient for the hospital.
Correct, Your Honor, but what I'm saying is that the 5 days, I would dispute the hospital's characterization of whether that 5 days in the emergency department was necessary, whether she needed a private room, or whether in fact this was somebody who, in other circumstances, really was in need of a medication adjustment. There was testimony from the doctor that her agitated state was partly due to the thyroid issue. The agitated state was probably partly due to being taken out of the line or wherever she was at Logan Airport by a police officer and hospitalized involuntarily. And then when she got to the emergency department, I think all the parties and all the amici recognize that that is not a place that is conducive to de-escalating somebody who may be experiencing
So in an
psychiatric
ideal
symptoms.
world, an ideal hypothetical world where funding is not an issue and the legislature will just pass the legislation you'd like,
Yes.
what would you say should be done?
If somebody is going to be brought to an emergency department as opposed to a facility, that assessment takes place as quickly as possible so that they can get to the door of the psychiatric facility as promptly as possible. Because in addition to what was mentioned before about the actual 12B determination, the right to counsel, the right to an emergency hearing, there's another important purpose of the legislature here that's thwarted by these 5 days detained and physically, mechanically restrained in an emergency department, which is that the
By
person...
the way, isn't your test the exact one that your sister just made? It's just you have a view of how quickly it can be done. She said the exact same thing. The standard is reasonable to do it as quickly as possible. I think she said the exact same standard you did.
With all due respect, Your Honor, I don't think we agree
I
on
know
that.
you don't
And-
agree, but I think the legal standard you both came up with seems similar.
Okay. When you look at 12B, there is language in the statute and the regulations that says they are supposed to be promptly evaluated or immediately evaluated when they get to the facility. They designate immediately as meaning 2 hours.
Yeah, we're talking about the
But
12A.
but overall, it's a 3-day max.
A 3-day maximum.
Under 12,
Right.
12B. So I guess in your, as quickly as possible, you certainly argue that 5 days
Correct.
wildly exceeded that. So we're trying to, I guess, nitpick to try to come up with, because the statute, of course, is silent on,
Right.
on any time period.
Well, I would say,
So in practically speaking, it may be impossible to go back to eliminate the emergency departments and go right to a psychiatric facility because of bed space and the like. So can you give us any idea of what your parameters are?
I think it would be in the number of hours. I think
Okay.
that's the amount of time that's required if there's a medical clearance that's necessary. And I would point out that under
So
DMH...
hours, not days.
Hours. DMH regulations require a complete physical examination plus lab tests at the psychiatric facility once the person is examined. So medical clearance,
Quite able to do it. How is it if it's under 12E, and the judge makes the necessary findings, you go right to a facility? There must be a reason why it can happen from the court, but it can't happen with a pink paper.
yeah. I don't know, Your Honor. I'm guessing that the numbers of 12Es are far fewer than 12As.
Sure.
But it's not just the 12E situation. The court clinicians get involved and find a bed, as we know, in Section 35s immediately, in 15Bs, in 16As, in 12Es. So the court clinicians are involved in finding a bed for someone who needs to go directly from a court in those various
So
situations.
if the hospital cannot accomplish this, or the emergency room cannot accomplish this within a matter of hours, what should they do?
Again, I think that the 3 days, if the statute is read to have a combined total of 3 business days from
So
start
you'd
to
go from
finish.
from hours to 72 hours would be the max.
At the outside, and
That's what
how
you're saying.
they, allocate that time, I think that gives them flexibility. But ideally, I think Justice Gaziano was saying in my ideal world, what time period would we be talking about? And we'd be talking about a period of hours. And this question about reasonableness, and is that determined, why isn't a clinician continually reassessing and looking for a bed sufficient? I just do want to point out that Massachusetts has a strong tradition in these cases of where there's a constitutional right involved, like bodily integrity, like privacy, in the Rogers case involving medication, the Sakowitz case involving withholding life-prolonging treatment, of saying we're not going to delegate these decisions to clinicians. There's a role for judges.
So, I'm sorry, go ahead. I was going to say, under 12A, so what, I'm not exactly following, who is it that would find the bed under your reading of 12A?
My understanding is that there is some type of central bed registry.
There is?
That
There is at
exists.
present?
I'm sorry?
There is at present a central?
That is my understanding. Again, I don't know that
So a
that's
police
in
officer is somebody
the record.
who is legitimately of concern in the back of the cruiser. Where do they go?
Currently,
They go to
I-
the ER.
I-
No,
right.
but where, in the ideal world, with the registry in place, would they call it up themselves?
I don't personally have experience in how they access that, but I am confident that if this court were to say that that's what's required, then, you know, with the resources that we have available, we can figure out a way for that to
That
be
leads me to my
accomplished.
question. So, I mean, we don't deal with we don't create an ideal world. We interpret statutes in the Constitution. You are telling us that 12A essentially says, based on reason to believe, you can restrain somebody and then you can bring that person to a psychiatric facility. And that's what are you saying that that's what we should say must happen?
I'm saying that if the statute is read as it was drafted and as it was intended, that's what would be required. And I just
But
wanted
are
to.
you saying that we should require that, even though that may not be so wise in the real world for it to happen that way?
Well, that's why I gave an alternative
Okay, but I
argument.
guess the question is,
but-
so, I mean, this is a, I mean, I read 12A, I understand what 12A, I think, anticipates, but I also read the briefs, and I understand that there are issues of comorbidity, and they bring somebody in, you don't know whether it's a mental health issue, or a drug issue, or a physical issue, or a diabetic issue, and a number of psychiatric hospitals basically require there to be some medical analysis before they'll accept somebody. So do you really want us to say that you now must bring somebody directly to a psychiatric facility? Is that what you really want us to do?
I think that what I started to say before about the legislative purpose that's thwarted by bringing someone to an emergency department is also that they intend for someone to be able to voluntarily admit themselves promptly. That is another legislative purpose that's defeated by this time in the emergency department. So yes, ideally, the person would be brought directly to the facility where even if they met the criteria or if they didn't meet the criteria, they could get prompt voluntary access to voluntary treatment. So
you're saying they should be brought to a psychiatric facility, and then they can be transferred from there to a medical facility for evaluation of the comorbidity or other issues?
I don't think that the issue of every psychiatrist in a mental health facility is an MD. Every psychiatric facility has medical capacity. So I'm saying I think that the issue of medical clearance, number one, it probably only takes, I think, 1.5 hours in the brief. It can be accomplished, except in maybe rare circumstances, at the psychiatric facility.
And if we say we're going to interpret 12A more liberally, and imagine that the person could be brought to an ER as opposed to a psychiatric facility initially, what do you say is the maximum limit of of the restraint that 12A permits before you kick in the 12B obligations?
Well, again, I think if we look to the statutory definition of what time period is permitted if someone were to be, brought immediately to the restraint period under 12A, they talk about immediately, and that's 2 hours under the regulations. That's what
Okay, and
the restraint period
what
is.
happens if they're brought to an ER and ER doesn't do it within 2 hours? ER basically says, I mean, I've never been in the ER for only 2 hours.
Nobody has.
And these individuals, fortunately, are a bit more complicated than I am. So what happens when they say, we need to do testing, we need to do some detox, we need to examine other particular issues, because especially if the person's homeless, they're likely to have a whole set of health issues that may make it difficult to know whether we're speaking about a health issue or a mental health issue.
I think that ideally, it would be done within a short period of time, and also I think the amicus brief of the Center for Public Representation suggests that there are other non-emergency department crisis interventions that can take place. But taking your example of somebody who's in the ER who may have these other issues that make it more difficult to treat them or to find a bed, that's where the alternative argument says at the very outside, the combined period of 12A and 12B has to be read to be no more than 3 business days.
But then are you effectively treating an ER as if it is a facility and saying basically the 12B obligations must kick in when you go to the ER, even though statute speaks of a facility and defines a facility as not being an ER?
I would hope that the effect of that would be that the facilities, which the hospital has said in its brief and in argument here, need that time or want that time, or at least a large majority of that 3 days to do their own assessment, would somehow step up so that the allocation of that time would be a limited period of time in the ER, and a greater balance of that 3 days takes place in the facility. I think there is some suggestion, and I can't recall whether or not it's in the CPR amicus brief, but I think with DMH's expedited admissions policy, there's certainly some suggestion that some of the private psychiatric hospitals were refusing to take people when they in fact had the capacity and the ability to take
Now,
them.
So let's take that example.
Yeah.
So imagine somebody who is homeless, undocumented, and appears to have a serious mental health issue, such that the police officer brings the person in. Nobody wants the person. Probably does not have any health insurance. Let's assume that after 3 days, they can't find anybody to take them. What's to happen?
I think it depends on what's happened in that 3-day period of time, whether there has been enough stabilization that the person...
Let's assume they've done everything in good, they've acted in good faith with all best efforts to find somebody, and nobody wants this particular individual.
I think 2 things. One, I think if the 3 days is the maximum has been reached, then yes, they would need to be discharged. I think the other question that wasn't really briefed but is raised as implicit in your question is, what if the person then somehow voluntarily, agrees to stay for a longer period of time for there to be a bed search? And I think that's fraught because we don't know how truly voluntary that would be. They'd be waiving a time limit. They'd be waiving the right to counsel. They'd be waiving a lot of things. And if it were to be truly voluntary, it would mean that they'd have to leave if they decided to leave. And very often when people are restrained or detained, whatever word you want to use, in the emergency department, it's under security guard. So as we all know, it's a very, very complicated issue and set of hypotheticals that we could discuss.
Could emergency rooms legally decline to receive people in these circumstances? The gentleman, for example, that the judge was just describing, the homeless person who was also an undocumented person.
It's a good question. I think it involves federal law, the EMTALA statute, and other statutes that I'm
Well,
not
if the answer is
quite
no, that
familiar
they
with.
couldn't, what do we do then with hospitals who are put in this position?
I'm
If
not
hospitals cannot decline, they must
If
allow...
emergency departments
If
can
emergency
decline.
departments of hospitals may not decline to have people come in these circumstances, what do we do? What is the hospital to do?
Like I said, I think that if the alternative argument is the one that the appellate division ultimately utilized is accepted, that's a period of 3 business days.
And then what happens if they can't do it within the 3 business days?
Then the person needs to be
Walks.
discharged.
He walks. Yep.
And do you want us to, again, I know we don't deal with the ideal world, but say you're sitting here, compassionate person like you, these are your clients. Do you want us to impose this immediately, knowing that there aren't the beds? What do you want us, how should we structure this if you want us to achieve your result, but the real world actually can't accommodate it? So how would we do what you want us to do in the best interests of your clients?
I think that one approach would be to take the approach that the appellate division took,
I
and
think that's a workable solution, the appellate
I do
division.
think it's a workable solution. I actually think less time than the 3 days is a workable solution. I think that DMH and the Commissioner of Insurance, the Commissioner of Public Health have already made a start in trying to build an infrastructure and trying to decrease the numbers of times that psychiatric facilities refuse to take a person when they actually do have the capacity to take a person. And again, I think that, you know, if this court were to say, certainly as a matter of statutory interpretation, but more importantly of due process, that this is what's required, I believe that.
But isn't the result of what you're doing, they're going to release the chief's example, they're not going to force the private facilities. McLean isn't going to open its doors to these people. You're going to force them onto the streets, aren't you?
I think DMH, through its licensing ability, has the power to curb or to put some parameters around the psychiatric hospital's ability to refuse to take people. And
We're
they've
not
already
talking
begun
about a
to do that.
refusal to take them. We're talking about nowhere to put them, which is a slightly different thing. I mean, if there's no beds there, no beds. And so what then does the emergency room do?
Well, if I can give an example of what the DMH process of this expedited admissions has looked at, when a hospital says we have no bed, they may be talking about we don't have a bed that would be appropriate for this person, meaning, or a staff, meaning they need one-to-one staff, meaning they need to have what DMH has termed specialized capacity, or capacity to address specialized population, somebody on the autism spectrum, a young person, somebody who could be in the psychiatric facility but needs additional staffing levels. So there's a lot behind, you know, a psychiatric facility saying, sorry, we can't take this person, we don't have the capacity. DMH has tried to say, well, how can we increase your capacity to take this person? So it's not strictly a shortage of beds, but also I think that the CPR amicus brief has demonstrated that there are mobile crisis services, there are peer-run respites, there are clinical interventions downstream before the person gets to the emergency department that also probably haven't been given enough attention. So again, it's a very complex, multifaceted
Do you
problem.
disagree with the hospital's stated, well, I suppose its goal of not having any incentive to keep people longer than they must? Do you disagree with that? Do they have incentives to keep people longer? Are they doing this only because they have no choice?
Again, I think it's complex. I think there are a number of institutional considerations that may come into play. I think it's easier to err on the side of safety and keeping somebody in the hospital than to potentially discharge somebody who might be at risk. I think in the case of my client, CR, I don't know why the determination was made that she needed a private room, or who made that determination, or why there was that delay. So I'm not suggesting any bad faith. I'm just suggesting that this is a problem of ER boarding that's existed, and their own doctor testified, you know, that it can be days to weeks, and that it's not an infrequent problem. So I'm not suggesting bad faith, but I am saying that it's a multifaceted problem.
Okay, thank you. And we'll take our morning break.
Thank you.